the Marquez case, it makes New Jersey unique in the United States, and the sexy part of the case, of course, is the language issue, with the responsibility for the police to let defendants know their obligation to submit breath samples in a language that they can understand. That's the essential holding of the case. But for our purposes this evening, in terms of putting defenses together, there's a couple very important things. First of all, you should understand that the elements of the offense of refusal have been redefined by our Supreme Court. You can't look at the statute and find the elements there because they're not there. What the court has done is taken a couple of cases, including State v. Wright, and cobbled it together with both 39450.4a, which is the refusal statute, together with 39450.2, which is the implied consent law, and taken little bits and pieces of each one of them, put them together, and come up with a new definition of the elements of the offense. And I'm not sure that this is filtered down to the prosecutors yet. This is the old definition that came out through State v. Wright, 1987. And again, this is now no longer good law. A careful reading of the two statutes, the two I just told you about, reveal 4 essential elements to sustain a refusal conviction. Okay, 1, the arresting officer had probable cause to believe the defendant had been driving or was in actual physical control of the motor vehicle under the influence of alcohol or drugs. That's the first thing they have to prove. And remember, all these have to be proved beyond a reasonable doubt as a result of State v. Cummings. 2, defendant was arrested for driving while intoxicated. 3, the officer requested the defendant to submit a chemical test and informed the defendant of the consequences of refusing to do so. Now, this requires some discussion. I'm going to hope you'll put in your notes. This is where the kind of the essential holding of Marquez comes in. When the officer informs this individual, he has to be informed, number 1, in a language that he can understand. Okay? That's number 1. And number 2, and this kind of ties into the State v. Schmidt case, which is before the Supreme Court right now. We have a situation where if the defendant initially gives a refusal that is equivocal in some sense, then it's incumbent upon the police to read the second part of paragraph 36. So you really have to include this as kind of subcategories of the third element of the offense, again coming through the case law. That it was done in a language you could understand, and if there was some equivocation about whether or not you should take the test after the first part of paragraph 36 was read, the state of the law as of today, the appellate division version of Schmidt, would require a reading of the second part of paragraph 36. So kind of put that in there as well. And finally, 4, thereafter the defendant refused to submit to the test, and acts constituting a refusal, we'll talk about a little bit. I would suggest to all of you, when you're trying one of these cases, you write all these down on a piece of paper and just kind of go through them as the prosecutor's putting his case on and see what any evidence, if any, he puts in on each one of these 4 elements, and make sure that the evidence that goes in there is done by proof beyond a reasonable doubt as a result of the Cummings case. Were you guys aware that the statute had been redefined, the elements have been redefined as a result of the case law? Were you guys cool with that? Oh, good. Then you learned something tonight, all right? We have attempted operation here with Mulcahy because of the business about the operation. So attempted operation of the car is also going to satisfy the element of the operation, all right? Now, the second thing that we need to talk about tonight is critically important, dealing with the Supreme Court taking away the defense, which we've used in the past, saying that our client was too intoxicated to take the test. And I use that with great success. And prior to the publication of the Marquez case, there was case law to suggest that if you have a situation where the defendant is kind of lying down on the ground, passed out, and the officer's reading paragraph 36, it says, all right, now will you take the test? Hey, will you take the test now? There's actually a published case on that. I think I might have the citation to it in your materials. It was an administrative law judge report for back in the era when the motor vehicles was handling the refusals. And they said under those circumstances, where the guy's literally passed out, intoxicated on the floor, you can't expect that he's going to be able to submit to a breath test. But just the general proposition that he was too intoxicated to take the test is really out now. Take a look at this language in the Marquez case, okay? It is no defense to a refusal charge for drivers to claim that they were too drunk to understand the standard statement. In other words, it is not necessary for the state to prove the driver actually understood the warnings on the subjective level. If properly informed in a language they speak or understand while sober, drivers can be convicted of the implied consent and refusal statutes. Voluntary excessive drinking cannot and does not void the statutes. Indeed, that type of voluntary behavior is fundamentally distinct from a person's lack of ability to understand a foreign language. Okay? Everybody cool with that? Now, I want you to think about this a little bit, for what it says and what it doesn't say. And it'll make a little bit more sense when we discuss this in the context of the case that got decided last week, which was the Rodriguez-Alejo case. You're not going to be in a position where you can say your guy was too drunk to understand what he was supposed to do on a subjective level. But let's face it, you do get situations where someone is highly intoxicated and incapable, either physically or, just mentally, of submitting a breath sample. And by that I mean the defendant just doesn't have the wherewithal because of a high level of intoxication to blow a proper sample or to understand the instructions that the officer is giving him. This is different than what the Supreme Court is letting out. I mean, if someone just refuses to take the test on the basis he was too drunk to understand paragraph 36, that's not going anywhere. But by the same token, if you have somebody like in the Rodriguez-Alejo case who says, yes, I'll take the test, or minimally communicates that he wants to take the test and then is unable to successfully do it, either because he can't understand what the officer is saying to him, or just physically can't give a good sample because of a high degree of intoxication, it seems to me that that's something different. Can you guys understand the distinction here? Yeah. So you'll be mindful of this when you have a very highly intoxicated guy, all right? And I mean, if he's all that drunk, maybe you'll catch a break, the cops will take him to the hospital, and they'll have a blood sample for you to show a high degree of intoxication that you could rely upon. Many times you'll also see this happen when you have synergistic effects going on, where the defendant's had a moderate amount of alcohol, but he has some type of substance in his body, a medicine or a CDS or something of that nature, where the two substances are combining to create a result that neither one of them would do independently. The two of them together have a real wallop where independently they wouldn't, okay? So kind of keep this in the back of your mind as a possible defense when you have those situations. And if your notes, would you put down that you cross-reference this to this Rodriguez-Alejo case, which we're going to talk about in a couple seconds, all right? In fact, we're going to talk about it right now. This case was published last Monday by the Appellate Division, and there's something very subtle going on here, and I want you to all be aware of it, okay? I'm not sure that the Appellate Division either understood the mechanics of what goes on in a drunk driving case, or maybe they did understand it and wanted to duck the issue, all right? Now, first of all, understand that this is an older case. It took a long time to wend its way up to the Appellate Division, and it occurred at a time before the alco test was in play. This was a breathalyzer case, all right? So let's kind of jump ahead to the current era and talk about alco tests for a second. You all know that as a result of the Chun decision, when the police are asking an individual to provide a sample of his breath, there's certain instructions that the officer has to give to the individual. And the Supreme Court actually quotes it, Justice Owens quotes the language the police are supposed to say to the subject when asking for a breath sample. I want you to take a deep breath and blow continuously until I tell you to stop. And of course, while the sample's going in, the officer's monitoring to make sure that the number of lights on the instrument go on so they have a sufficient breath sample. All right, you're all familiar with that language, right, out of the case? So there is some minimal level of communication which is necessary between the subject and the officer when they're doing the test, okay?